Hello, everyone. My name is Lauren Antone, and I'm the Senior Marketing Events Coordinator at MAR, as well as the producer of our free webinar series. Our webinar today is Do Your Due Diligence, How to Not Get Sued When Representing Buyers and Sellers. This webinar will cover both the practical and required due diligence items listing and buyer's agents should and should not perform during representation in real estate matters. Topics will include permits, septic systems, field cards, stigmatized properties, deed review, seller statements, home inspections, condo listings, multi-unit dwelling and in-laws, tenants, and additional agent responsibilities. After our live session, the webinar will be recorded and added to our website at marealtor.com. If you have any questions throughout this session, please type them in the chat box on your screen and we'll hold a Q&A afterward. Our presenter today is Karla Heine Goodale. Originally hailing from Macro Island, Florida, Karla moved to Boston area over 20 years ago and almost immediately entered the real estate field as a realtor. Throughout her years on the front line working with buyers, sellers, builders, investors, and flippers, she gained valuable experience and insight into all aspects of the life cycle of a real estate transaction. Her passion for real estate and keen interest into the inner workings of real estate closings drove her career path in a different direction, law school. Fast forward to 2021, Karla is a partner at Lieberman Law Office. Her practice focuses on real estate law, condominium conversions, residential and commercial conveyancing, I want to make sure I'm saying that right, financial portfolio growth through real estate acquisitions, and business entity creation. She represents buyers, sellers, and lenders in residential and commercial real estate closings. She works as a liaison with banks and homeowners, managing real estate short sale approvals, mortgage foreclosures, and is an experienced client advocate negotiating mass health liens payoffs. Karla's background as an active realtor in the greater Boston area gives her a unique perspective. She guarantees to accomplish every matter in an effective, expeditious, and cost-effective manner. Karla and her colleagues perform closings throughout Massachusetts, Rhode Island, New Hampshire, Maine, New York, and Florida. Her keys to success are being an effective communicator, putting people before profits, and living by the golden rule. Now, over to Karla.
Hey everybody, welcome today. I'm very excited for this topic. I teach this a lot. I teach this as a CE. I teach this to, individual, like small groups. And so lots of things to cover here today. Some things are going to be opinions and best practices, although no hard and fast rules. And other times we have, what we call black letter law. There's no deviation. What I'm telling you is, what the law is. I do understand sometimes that what the law is and how we quote unquote do it on the streets is a little bit different. And I acknowledge that, but when in doubt, I'm gonna, as a good attorney will, defer to the law. So bear with me as we go through some stuff, and I will definitely be answering any and all questions afterwards. Even if the program runs a little long, I will stay on to answer all those questions. So what are we looking to not do right now? It's to let's not get sued. And that is really, I think, especially in today's market, a very big thing. I have had 3 people call me in the last 5 days saying that their clients are threatening to sue for things of my buyer's agent pressured me into waiving an inspection. Well, no, it wasn't pressured. It was, if you want your offer accepted, I suggest you waive your inspection. Or things about my buyer's agent didn't do enough due diligence before I accepted this offer, and now I'm in the home and I wish I would have done more. Where is the line of what is the buyer's responsibility, what is the seller's and or buyer's agent, listing agent responsibility? So let's talk about it a little bit about that. Not now, Lauren, oh, here we go. Okay, so the objective of this course is to educate licensees on reducing their risk as much as possible. We want to ensure information is accurate. We want to ensure information is accurate, that we can verify it, and that we can advise our clients to the highest and best, both in when they need to do their own due diligence and when they need to seek legal counsel or another expert, be it a loan officer, be it a mold, septic, lead expert, anything else like that. Remember, I see a lot of times agents, especially agents who have been in the business a long time, really starting to enter into the field of they are acting as an attorney because they have seen a lot of purchase and sale agreements, or they've seen a lot of use and occupancy agreements, or they've seen a lot of things, and they figure, well, I'm just going to lift this language out. The Realtors Ethics Code, Article 13 states realtors should not engage in activities that constitute the unauthorized practice of law and shall recommend that legal counsel be obtained when the interest of any party to the transaction requires it. Now, the question is, when is it required? Well, if it's outside your scope of expertise and you're not a lawyer, then I would suggest it probably requires it. The one thing I ask people when they tell me, oh, how much does it cost, or do I really need an attorney? My joke is, how much did you spend on flowers for your wedding if you were ever married? Because a lot of times that number is, in the thousands, if not more. And you're trying to make the biggest transaction of your life, 350, 500, a million. And then you're trying to figure out if a couple $100 is worth the money. And I will tell you every single time it is. Okay. So, real estate licensees are not attorneys unless they pass the bar. Do not mistake your diligence for legal representation. And we're going to talk about where you might be dipping your toe in there to get yourself sued. Okay, so first of all, who's the seller? And the seller is establish that the sellers have legal representation and begin a dialogue with their attorney by way of introduction very early. I like to tell people that if you have gone on a listing appointment and you think you're going to have a client, that's a great time to get me involved. I can go ahead and do some of your due diligence. I can go pull the deed, make sure that the seller who says that they're selling actually has the power to sell. If someone's died, we can look at what that means. If there's probate going on, if there's a divorce going on, if there's a bankruptcy going on, if there's someone who's out of the country, especially with COVID, that's a problem. We want to flesh out as many of the potential pitfalls or delays in closings right up front. Okay, so let's start with the very basics. If the seller doesn't know a fact, you don't know a fact. We do not make assumptions. Assumptions are your enemy. We do not speculate. Speculation is not fact. So unless you perform due diligence, you don't know something. So what does that look like? Okay, I just said assumptions are your enemy. Document, document, document. The number one thing, and it's somewhat easier and somewhat more difficult, is documentation. We have all of this great technology to us. We can use Siri to say, hey, write me a note. Hey, Siri, send myself a text. Hey, Siri, all these different things. We can be on the phone, hopefully not driving, sending ourselves a text message, an email. We can document the when, the where, and everything else like that. At the same time, we're all moving so quickly that it's hard to get it all down, and it's easy to forget or say, I'm going to do it later. I can tell you, I don't delete any emails. Every email of any transaction I've ever done is there. Any little note I have ever written on a scrap piece of paper or anything else like that gets scanned in a file. And I can't tell you how many times 3, 4, 5 years later, someone comes back to me and I go and I look in the file and I was like, nope, on this date, this is what we talked about. Or nope, this is the email that I sent you on this date telling you to do X, or showing you a document, or something like that. So I always tell people to, when you find out a piece of information, write down the date, the time, and who gave you that information. So if you're talking to town hall, finding out that it's a legal 3-family, who did you talk to? Do you have a picture of the field card? If you're talking to someone that says it doesn't have to be connected to town sewer because you're on ledge by the river in Worcester, then who said that to you and when? These sorts of things are going to be invaluable to you should you ever get brought in front of a court and get sued for anything. Okay, so let's talk about, when do you know what you know and when do you not know? And what does that look like? The cases that I'm going to put before you side by side are relatively similar, but as we all know, the devils are in the details. Okay, so what does this look like? So on the left-hand side of your screen, Quinlan v. Clasby. The broker was told, the seller told the broker that the property was a 3-family, and therefore the broker marketed the property as such, even though only 2 of the 3 units were lawfully under zoning as, a 2-family versus 3. Broker inspected the property and found 3 separate apartments, had no reason to suspect that the zoning was incorrect, and did not review the field card or the building records. The court found that since the broker did not knowingly misrepresent, in this case, they could rely on the information from the seller, and the broker was not responsible for reviewing zoning compliance. They could rely on what the seller told them. Now, I will put a caveat to that. Back in my real estate days when I was actually listing and stuff, you have to also use common sense. So I had known that the Mother's Day storm of, I think it was 2005, had happened because I had been on the street helping my friends pump out their basement. And everyone on the street, there's a creek at the end of the street. Everyone on the street in this town in Peabody got water in their basement, and we had pumping parties. And a couple years later, I went to list one of the houses on this street that I knew I'd met these people at the pumping party. And so I said, "Oh, have you ever had water in your basement?" And they said, "No." And I said, "Oh, are you sure? Not even the Mother's Day storm?" And I said, "Nope, we didn't have any water then." Well, I knew that that was an incorrect statement. So although I could have relied on what the seller was telling me, I knew it was untrue. And therefore, I didn't feel comfortable representing that no water had ever been there, even though I didn't have any proof that it had been other than my own memory. So you have to remember, jokingly, I tell people if it feels funny in your tummy, you probably shouldn't be doing it. So think about that. Now, on the other side, there's the DeWolf versus Hingham Center. So previous owner of the property was unsure. There you go. They don't know of the zoning and gave the broker two possible zoning classifications. One which didn't exist which was residential business. Usually it's like a mixed use, but they called it residential business. The incorrect zoning classification as a residential and not a business made the buyer incapable of running their business out of the property, which means that there was frustration of purpose. They bought a property thinking they could do one thing because the seller held it, or listing/seller held it out that way, and they couldn't do it. So given the lack of certainty in the zoning classification and the fact that the broker, put that representation down, even though they did no extra due diligence and did not fulfill their duty of reasonable due diligence, that is what made the broker responsible and guilty of lack of due diligence. So, like I said, these are very similar cases, but it's what they knew versus what they didn't know. And specifically, someone said they didn't know. So, okay, we want to ask a lot of questions, and this is going to bring me into the seller's disclosure that we're going to fill out. So, ask a lot of questions. Are there any betterments or assessments coming up, seller? Are you going to be required, if you're on town sewer, private sewer, are you going to be required at closing to tie in to town septic? You don't know this, agents. I can promise you don't know this, because 3 different instances where I would think, well, why wouldn't you? I helped friends of mine sell a house in Worcester, the one I talked to you about. They had a cesspool. Who has a cesspool in the city of Worcester? Well, the town came out and they said, nope, this is the cesspool. We don't have any way to actually tie you in to city sewer. And on top of that, there's no place for you to put an actual septic system. So this cesspool is staying. I've had other times where, when you go and look at a house and it's like in the rear, that a house, even though it was in a city, had no way to access the town sewer. So they were this anomaly in a town where they were on a septic system, although everyone else was tied into sewer. So just because a town has like a blanket something doesn't necessarily mean that there aren't exceptions. So you want to ask the town that. A joke that I always say, back in 2004, all of a sudden the green line was coming to Union Square and everybody was excited and people were buying, swooping up property. Oh my gosh, the green line's going to be here. This is going to be a great rental market and everything else like that. Well, we're 17 years later, and the green line has still not arrived at Union Square. Same is, is there gas on the street, or is there gas available to a house? I listed a house one time and I knew other properties on the street had gas. And so someone at the open house asked me, can you connect to gas? And I said, yeah, sure. I don't know why not. Let me call up. Well, the gas line stopped 2 houses down. And so the sellers or the new owners would have had to pay to bring the gas line up to their house, so an extra two houses, and then connect. So what would normally be maybe like a $1,500 expense was going to be over $10,000. So I could have easily misrepresented, like, yes, there's gas on the street, but can it connect to the house? Well, yes, but for a big expense. Solar panels, are they rented? Are they owned? Is flood insurance required? If your seller doesn't have a mortgage, they might not know that they're in a newly classified, flood zone. So lots and lots of questions to ask. So verify, verify, verify. Even once you sometimes get answers, it might behoove you to do a little bit more digging. Now, it's very interesting in this market today because we've got a lack of properties, an abundance of buyers. Everyone is waving everything everywhere. So the question really becomes from a listing agent and sellers, what do we really need to do to get this house sold? We can say nothing. We don't have to look at permits. We don't have to represent really much of anything. And we're going to be able to sell our house for above asking, and it's going to be beautiful. So why would I do any more? Is really the question. But the answer is, if the question is going to come up, do you want the answer and do you want to be able to head it off? If the buyer goes and looks at permits because you're like, we're not looking, we're not disclosing, we don't know, do your own diligence, and you all of a sudden find out that you have 3 or 4 open permits, and now this buyer wants them closed or wants out of the deal, well, you now know anyways, and you're going to have to now disclose, because as a realtor, once you know, you have to disclose. And you might have been able to get this cleaned up ahead of time, so it wasn't going to be a problem once you've already accepted an offer, or it wasn't going to be a delay in closing because we're trying to hunt down the contractor to come back and close permits, or something like that. So it's your decision how much more due diligence you want to do that would not otherwise be required. And it's a conversation also to have with your seller to figure out what do they want you to know that they're therefore you have to disclose, because the seller doesn't have much requirement for disclosure, but the realtor has responsibilities for disclosure once they know. Okay, so agents have both the responsibility to their principal, which is their seller or buyer, and the broker owner to reduce the risk of liability for themselves, their company, and the consumers they represent relative to the following aspects of representation. So what's number one? Oh, I'm sorry. Actually, I forgot about this slide. So we are not holding ourselves out as an expert. If you are not a licensed appraiser, you can give some speculation, but you're not an appraiser. If you're not a home inspector, you're not a home inspector. If you're not a specialist in septic, mold, lead, asbestos, then you're not that. You're not an attorney. You're not a lender. I have been doing something with loans for over 20 years, and I can promise you that when my clients call me up, if it's not a very vanilla, generic question, I say, I'm sorry, you're going to have to talk with your lender, because the lending requirements are changing regularly. The loan application just changed in January. It used to be that FHA loans would not allow holdbacks for septics. Well, now some of them do. Sometimes it depends. It used to be that, you could say, an appraiser is always going to do X, Y, Z. Well, now there's waiver of appraisals, or there's, called what we're calling desktop appraisals. So we don't want to go down that route. What you want to do is you want to find the answer, or you want to find the source of the answer, and you put the due diligence on your buyer or seller. And I say that not to be lazy. I say that this is not your life, your money, or your future, as I tell my clients all the time. I'm not the one who's going to have to go live in that neighborhood. I'm not the one who's going to have to go live in that house. I'm not the one who's going to have to send my kids to school there. So you want to make sure that you are providing them with information for them to do their own due diligence. If they want to find out, can this 3-bedroom house ever become a 4-bedroom septic? I would say you either accompany them to the town for that answer, or you provide the name and number of the person that they need to speak to at town hall to find that out. I would not get that information for them. And again, this is not to be lazy. It's about not getting yourself sued because you asked one specific question, and had the borrower or buyer been there and heard that answer, that might have prompted 2 or 3 more questions that would have gotten to an answer that they didn't like. So it's really about making sure that your buyers and sellers have all the information to also do their own due diligence, or you do it together. Okay, so we're verifying ownership. I can't tell you that I think the number one time that people tell me something is that, no, my house is in a trust. Well, that's all good and fine, but the person who established your trust had to make sure that you actually put your property into the trust that you established. It's probably the number one thing I come across that I was like, well, that's great that you established a trust, but the deed was never recorded that put your property into the trust. So that's number one. Verification of ownership. It might have that both the buyer, two buyers on it, but who actually owns it if there's someone who has passed away? Is there a divorce decree out there that says someone was supposed to have already, you know, signed over a deed? Um, there's a lot of different questions. So I think the first thing that you do is you want to go start hunting around at the registry of deeds, not at public records. Public records is a jumping off point because public records only updates the record when property sells for actual consideration. So not for a dollar, not for $100, not for love and consideration. It needs to be someone bought it for $200,000 for actual whatever it would have been a fair market value. So if I put my property into a trust, I conveyed it to myself for a dollar. So it won't show that it's in a trust in public record. It's just going to show that it's still in my name individually. Um, so that's number one. Number two, you're going to look at the deed. Are there any rights of ways or easements that are on the face of the deed, meaning contained actually in the deed? Are there any life estates? So, if Grace and Joe own it and Mary reserved a life estate, Mary is 100% involved in this transaction. Mary has to sign the offer, Mary has to sign the PNS, and Mary has to sign the deed. Are there any restrictive covenants? I had one recently that I'm working on that the restrictive covenant says that the lot the lot cannot be increased or decreased in size, and the lot lines cannot be changed in any way for 30 years. Well, the buyer who's buying it was hoping to go buy the lot next to it and do like a big compound and everything else like that, which their actual plan is not allowed due to the restrictive covenant, and the restrictive covenant has only been in place for 11 years. So had we not caught that early on, that would have become a problem. And honestly, it was caught too late because by the time it got to me, they had already had the offer accepted, home inspection, everything else like that. And now all of a sudden I told them, yeah, what you're planning on doing, you can't do. And the whole deal fell apart. And then the sellers ended up taking it off the market. So there was a lot of wasted time and energy where we might have been able to get that sorted out right up front. Okay, so what you're looking at for the registry of deeds, you want to run both the property address and the owner's names. So we're looking for how many mortgages do they have? Are there any liens like a tax taking or a credit card lien? Are there any orders of notice like foreclosure? Are we registered and recorded land? There's two types of lands in Massachusetts, registered and recorded. Sometimes they're both. If they're both, that's really important for the buyer to know because all of their recording fees are double, and that's actually a disclosure thing. Additionally, what if it's in two towns? We need two municipal lien certificates. We might need additional searches and stuff like that. So it might add to the timeline of how quickly things can happen in a transaction. And then again, divorce, death, and probate. If someone has died, that could actually be no issue whatsoever, and it could be a huge issue. Upon death, you have to look at when it says the grantor is this and the grantee is that. In the grantee section, how many people are named? If there's one person that's named, that could be a problem because did they have a will? Does it have to be probated? Did that will have a power of sale in it? If not, we're going for probate. You're probably not closing in COVID times. In the best of times, it's usually 6 months. Sometimes it's a year. So you think that you have this, you've listed it, you've done everything, you have a buyer, and now all of a sudden we're not closing. Same with if it's registered land and there was a death and there was no one else. You have to go to land court and get the new deed approved. That could easily be a 3 to 6 month process. If we are in probate and there was a will, has the personal representative been appointed? Because that's a court thing. So the minute you ever hear or think that there was a death, you kind of need to put the brakes on the listing, the open houses, the offers, and everything else like that before you get too far down the road and then find out that you've completely wasted your time because we can't close anytime soon. Okay, field card. Perfect example, that multifamily, the 2 to 3 family. The field card is the building card. The field card is going to tell you what the house is. Is it a two-family? I sold a house in Revere one time. It should not have been a two-family. The basement unit was completely underground. It did not have a second form of egress. The egress was to walk upstairs and go through the basement quasi door into the kitchen of the other unit. But in Revere, I went down to town hall. It said legally conforming two family. I took a copy of that, put it in my slicker at the open house, put it up on MLS, and everyone said to me, "Are you sure this is a two family?" I'm like, "City of Revere tells me it's a two family," although it did not, I believe, meet the requirements. So you can only, you know, represent really what the field card says. And I get a lot of times when people ask me, it's like, well, they're using it as a 4-bedroom, but the field card only says 3. And I say, well, do you want to get yourself sued? I'd say, put it in there as a 3-bedroom. I'm sorry if I said family. Put it in there as a 3-bedroom, and then put in the description that fourth room is a bonus room or something. People can figure it out. It gets a little bit tougher when all of a sudden field card says 1 bathroom and there's 2.5 in there. Like, you can't say there's only 1 bathroom, because people are going to walk around and be like, why does this say 1 bathroom when there's 2.5? Because someone went and put, a half somewhere and then a full in the basement. You just got to be careful about how you're disclosing. I mean, especially in this market, people are going to buy, but you don't want to get sued because you held it out incorrectly. Same with parking spaces, a really big one for condos. Someone told you it came with a parking space and then it didn't, or it was exclusive use and it wasn't. It was the right of the management company to assign or take away at any given time. So we want to be looking at that field card and getting information. Another really big one is when field card says house is 1,600 square feet, but they have a full finished basement of another, 600 square feet. Well, are you, and they pulled no permits for it. So are you saying it's a 2,200 square foot house? Are you saying it's 16 with a finished basement? It's a fine line. You could definitely fall into it, although we all know in practice people use that square footage in their listings all the time. That's a perfect example of like what would legally be right and what do people actually do in practice. Okay, agents' responsibilities. Again, we kind of talked about this. Are we going to look if permits were pulled or not? You really don't want to know, but at the same time, if there's no permit, little permits I don't care about. Little permits, you installed a ceiling fan, okay, whatever. You went and did a complete kitchen remodel and put on a half bath, and there's not a single permit for it. Well, you should be prepared that that's going to probably cause you some issues. But again, if you don't know, you don't have to disclose, but it's probably going to come up. So you may not want to ask your clients, hey, all this work that you did you do it pursuant to a permit? Because you don't want to know, but that doesn't mean it's not going to come up. Okay, assessor's department versus the building department research. So these are 2 branches in the same town or city that usually don't really talk to each other, in the sense that the building department field card tells you what the property is. It's a single family, 3-bedroom, 1 bath. That's what it is. The assessor's department says we're going to tax you for whatever we see. So if we see 4 bedrooms, 2.5 baths, guess what? We are going to tax you on that. So the assessor's department and the building department are not necessarily the same thing. And the assessor's department is not where you want to get your source from. It's actually the building department. Okay, seller statements. The bane of the attorney's existence. Because are they helpful? Absolutely. Are they great because they're full of knowledge that the buyer may want? Yep. And how many times do the sellers fill them out quickly just to get it off their plate? And they are the number one thing that buyers can use to sue sellers on after closing, because they relied on that information that the seller openly gave, only to find out that it was incorrect. So before seller statements are filled out, I believe that listing agents should impress upon their sellers that if you don't know, you don't know. Don't guess. I personally, when I was in, listing, I would not have my clients fill these out. I didn't think it was a good idea. So what I would do is say, hey, why don't you write me a list of what you know about your house? Do you know that the roof was put on in 2017 and you have a receipt? Fantastic. Do you know that the hot water tank is 8 years old and you have a receipt? Fantastic. again, if they don't really know and they're speculating and then you put it out, like that second case that we said, that's on you. So some agencies, I know brokerages require these seller statements. That's up to you and your broker. I'm just saying when they get filled out, make sure that they're filled out with a fair amount of due diligence and that you impress upon your sellers how important the statements that they're making really are, because they will be sued on them. Okay, lead paint disclosures. The seller fills that out first. It really is something that I don't understand how this ever got confused, that you send over a blank one to the buyer to sign and then the seller will sign later. The buyer is signing to the representations that the seller has made. Either they have or have not, they do or don't know about lead paint. They have or have not received the forms. They did or did not receive the 10-day opportunity. So listing agents, when you're filling out that listing agreement and all the other things that you're doing, that lead paint form needs to be filled out because the seller fills it out and signs first, then the buyer. Something that I like to say about lead paint and new construction and potential liability is that, especially with all of this, we love the old farmhouse look and everything else like that. You can have new construction and you can have lead paint. If someone went and sourced old, wide plank oak floors, reclaimed doors or old mantle pieces and stuff like that, you very well may have lead paint in that house. So I like to say that we always fill out lead paint, even if we write on it new construction, 2021 or anything else like that, because unless the builder is like, nope, every single piece of everything in this house is brand new and we didn't do anything, then you might be in trouble because you represented that there was no lead paint and you said you didn't need the form and everything else like that. So again, food for thought. We're going to skip over that. We got other good things. Okay, home inspections. I'll tell you my opinions. You all can decide for yourself. When I was a listing agent, I would usually show up at the home inspection to let the home inspector and the buyers in. And then, if weather permitted, I would go sit in my car. I did not want to hear what the home inspector said. I never want to see the full report. And I don't want to be given information that I might now have to disclose. I want to be close because if you can't figure out, where the electrical panel is because it's hiding behind a picture, or you can't figure out how to turn on the AC or the heat because it's a weird season or something like that, I don't want to have to go back and have a re-inspection. I want to be on site to be able to help out, but I don't want to hear anything because again, once I know, I disclose. Now there's a difference between actual knowledge and speculation. Actual knowledge is, well, look right there, there's a termite, this is termite damage. The inspector shouldn't really say that, but if you have a termite sitting right there, okay, that's a thing. Versus this could be black mold. Well, those are two totally different things. I am someone who, even after inspection, when I say if I want to see a pertinent portion of the inspection, I am very clear. Please send me that one page. I do not want the whole inspection. If anyone ever sends me the whole inspection, I immediately send it back and said, I did not ask for the whole inspection. I do not want to see the whole inspection. I have deleted this email. I have deleted it from my deleted files. I do not want to see it. I never read it. Please send me back what I asked for. Because again, that's proprietary information for the buyers. The buyers paid for it. So first of all, did the buyers give you permission to send me the entire thing? And two, me and my seller don't want to know. We really don't, because if you decide to walk out of this deal or it falls apart because you can't get your mortgage commitment, I know a bunch of stuff I now have to disclose. So my opinion is you either accompany or you don't, but you do not walk around and listen to everything that the home inspector says. I think that that is actually a bad idea in my personal opinion. Okay, agents. If you're going to put a condo on the market and you're in a price point and area where you will be accepting or at least entertaining offers that have an FHA or VA requirement, you should probably find out if the condominium is FHA approved. There are some resources out there. You go to HUD, Housing and Urban Development is what that stands for, HUD.gov, and you can find out. You can also call up a lender, like one of your lenders, and say, hey, can you find out if this in fact is an FHA approved condo? You're also responsible for getting, the master deed, the declaration of trust, the bylaws, rules, regulations, budgets, everything else like that. Rules and regulations, especially with bigger associations, are not usually included in the condo docs that you find online. They are separate documents and they change. And that's one of the reasons that they usually don't record them, is because, maybe no one wanted dogs 20 years ago. Now they do. Maybe smoking used to be okay. Now it's not. Maybe having rentals was okay. Now with Airbnb, it's not. They change. We need the separate rules and regulations. We need the budget. I could potentially go get the master deed and declaration of trust, but as a buyer's attorney, that is not my responsibility, and I will not take it upon myself, because if I miss something, then it's on me that I missed it. It is the sellers and or management companies' responsibility to get me that information. So don't tell me it's online. That's part of your job. If there's a right of first refusal, if there's a management company, it's never going to be on not never, very rarely is it going to be on a 2 or 3 family. It's going to be in a bigger association. Talk to the management company. You find out, are there any special assessments? Find out how long it's going to take to get a 60 certificate. The 60 certificate, for those of you who don't do condos much, it's a certificate from the trustees stating that, in fact, the condo fees have been paid in full through the month that we're closing. There's no outstanding condo fees, special assessments, anything else like that. How long does that special 60 take to get? How much is it going to cost? When does the seller need to make their next condo payment? Some management companies are like, it takes 2 weeks. So if we're closing, say, May 4th, they actually need to make their May condo payment probably the first or second week in April, so that we can ask for that May condo 60 certificate to be clean. So you need to start finding out about these things well in advance. Is there a move in and move out fee? And if so, who's required to pay it? Also, a lot of times I come up with people saying, well, seller's not going to pay the condo questionnaire fee. It's the buyer's responsibility. Well, you accepted a offer that you knew there was a loan involved. So if you did not put in MLS that it will be the buyer's responsibility to pay for the condo fee questionnaire, then my argument is it's on the seller. It's part of their due diligence and their cost of selling their property. So again, just put it in a disclosure or something like that in MLS. Okay. Yeah. And you can go ahead and reach out early. The buyers will need a certificate of master insurance. So that's something that you put in your listing portfolio if you're going to list condos. Okay, tenancy versus leases. This has been a nightmare during COVID, but there's a difference. So first of all, if the house is coming occupied, put that in there. Put how much the rent is, security deposits, rent, last month's rent, anything else like that. We're going to need that information for the purchase and sale agreement. We're going to need that for closing for adjustment purposes. So let's get that up front. If you list a house and you take on a buyer who says we want it delivered vacant, good luck. We cannot get people out of units right now. It's not happening. And even for those special situations where we can get people out, the courts are so backlogged that we're looking at minimum 6 months. So if you want your tenant out and you want to sell it with no tenant, I say get the tenant out before you ever list the property. There's tenancy at will and there's a lease. Remember, guys, a use and occupancy agreement, if someone is buying it as an owner occupied, cannot be longer than 60 days. And the lenders are not allowing you, like if it's 3 units and there's 3 units with leases or tenants at will, they are requiring at least 1 unit to be delivered vacant. So again, if you're trying to get 1 tenant out and we've all of a sudden got a 30 or 45 day closing date and the buyer went in and locked a rate, chances are we're not closing, because we're not getting tenants out. Tenants are not even being remotely persuaded by cash for keys. I've had people offer $20,000 for their tenants to leave, and the tenants are like, we're not going anywhere. So, is there a lease? Is it a tenant at will? Is there any pending litigation or evictions? These are all things that the buyer and the buyer's attorney needs to know. What are security deposits, occupancy certificates, if you have de-letting, anything else like that. Okay. Although we are not considered zoning and zoning or usage experts, we should do our due diligence and our homework, and that was the cases that I told you about earlier. Okay, so now when we're going on a listing, or when we're going through with our buyers, we're really looking and taking it. Do we see freshly painted rooms, specifically basements, ceilings, water stains, lots of rust on systems, things jimmy rigged, knobbed into wiring, these sorts of things. Like, we need to be asking questions, because again, the ultimate goal, if a seller is listing their house, they want to sell. You are listing the house because hopefully that is going to be a payday for you. You are in the job of buying and helping people buy and sell real estate. You're not in the job of wasting your time. And so these questions need to be asked up front. So you are looking, walking, and asking questions. Visual inspections by a licensee to maximize disclosure and minimize risk. Because again, you are always on the chopping block for getting sued. So the questions need to be asked and additional information researched if necessary. Okay. So in the purpose of gathering information is to minimize surprises when possible. Nothing worse than, finding out at a home inspection something big, or finding out after the offer's been, accepted, something big because the buyer asked something and you were like, oh, well, I guess I didn't know that. You don't know until you know. Okay, stigmatized properties. I'm not going to go into this too much, but just know that they're out there, and sometimes it's a thing and sometimes it's not. The fact or suspicion that real property may be or is psychologically impacted shall not be deemed to be a material fact required to be disclosed in real estate transactions. It is not required, but if you are asked, you have to be honest about it. So that's basically what it is. If someone died there, regardless of how, you have to, do you have to disclose that? No, but you might have, especially if it was any sort of high profile death, might be something that you just decide to rip the Band-Aid off. But that's a conversation with your seller, because you do not have to disclose that. Okay, in-laws and accessory units. Not all in-laws are legal, and not all in-laws are transferable. So some towns do not allow in-laws. So people will say this is an in-law. It's not an in-law. Sometimes, depending on the town, if the fire department shows up and you have a stove in a kitchen somewhere, they will make you rip that out before they'll pass you. We used to just take out the stove. Now a lot of times they'll make you take out all the cabinets. So if someone says that they're selling with an in-law, the first thing to do is to call the town and say, do your ordinances allow in-laws? And if so, is it by right? Is it by special permit? And is it transferable? I had one recently where we had to go through the process to be able to transfer it to the buyer. Okay, purchase and sale language. I, especially in these crazy times, are seeing a lot of things I don't like, and a lot of things that don't even make sense. I have to call up agents and be like, what does this even mean with these contingencies? I think it is very good if you're going to start waiving inspections. Well, inspections not as much. If you're going to start waiving appraisals, you really need to talk with your lender. What does that look like? Do they have the extra funds? Do they have $20,000? And just because they have $20,000 doesn't mean that that money is allowed to be spent. That $20,000 could be something that the lender is taking into account, that they're having reserves and stuff like that. So if they took that money out, all of a sudden they don't have enough in their account. So you really need to be talking about that. Just because you want to get an offer accepted and you don't want to put it subject to a seller selling their house or a buyer / selling their house doesn't mean it's not a fact. And does the pre-approval state that they have to sell their house? Because again, listing agents, just because it's not in the offer, the entire package is the package that was sent over, which includes the pre-approval. On a kind of separate note, but I think equally as important, those love letters, you need to be really careful that those love letters are not causing a potential lawsuit. If your love letter states, we're a same-sex couple with 3 children and my spouse is from Afghanistan. Well, there's 3 violations right there that no one should have known. If you had looked at an offer, you wouldn't have known that they were gay, that they or a married gay couple, that they had children, familial status, and that they weren't of national origin of the United States. Those love letters, I think across the board, are a very, very bad idea, especially because you can also The sellers want to sue sometimes because someone writes this lovely letter. I'm going to raise my kids and I'm going to do everything and it's going to be beautiful and I'm going to treat your house just like you did for the last 50 years. And the next thing you know, seller drives by one day and they've ripped down half the house. Well, then wait, what did you just do? You lied to me. I think what's a better idea than the love letters, and I think more impactful from a listing standpoint, is for the listing agent to say, we've been looking for this long. This is the offer that they're putting in. Here's their attorney, name and number and email address. Here's their loan officer, name, number, email address. Here's the home inspector, name, number, email address. We've already secured these 3 times for the home inspection. Boom, boom, boom. You're making it super easy for the listing agent and the seller to say, wow, these people are organized. They're on track. We're going to, boom, get to the closing table. The other thing about the love letters is that if you're not going to take them, if you have that conversation with your seller and you say this is a bad idea, you need to write in the disclosure that seller will not entertain, love letters or whatever we want to call those letters. Same with if you're not going to allow escalation clauses, you need to put that in the listing. Escalation clauses will not be entertained. You need to be setting the expectations for these offers because all offers and all parts of the offer are technically supposed to be presented to the seller. You don't get to pick and choose what they see. So if you're not going to show it, tell people that you don't want them. Okay, an as-is clause. An as-is clause is only as good as maybe, as the words. If willful non-disclosure of a known defect is found, the clause may not survive in court. So even though you guys say, hey, it was as-is, you recorded the deed, it's a buyer beware state, buyer do all diligence, too bad. If the court finds that there was fraudulent misrepresentation, then they're going to throw everything out and they're going to go after the seller and potentially you. Walking the line between a licensee and an attorney, I think, we've kind of done it. Learn to recognize red flags and when you're stepping out of your zone. And that's not just for attorneys. That's for lending. That's for septics. That's for inspections. That's for everything. The seller needs to go to the proper authoritative source to be able to get answers. If you don't know the information, know where to find the information and recognize the limits of your own knowledge. And lastly, do your homework and research, be the source of the source. So that's all I have. So we can go right into questions and we got 12 minutes left.
All right, well, thank you so much, Karla. If you have any questions, now's the time to write them in your chat box. It looks like we've got several questions already, so let's get right into it. First question, so it's agent's responsibility, not the seller's attorney, to check ownership. They said, again, wouldn't I have seller's attorney check the deed?
Yeah, absolutely. We do check the deed. What I'm saying is when you're ready to list the house, when you're, going on a listing appointment, call up your seller's attorney if the seller doesn't already have one and say, hey, can you do a quick search on this? So yes, it's 100% the seller's attorney's responsibility. But what I'm saying is, you've listed the house, you've taken pictures, you had an open house, you've done everything. And then all of a sudden I find out that we have to back everything up. So it's your responsibility as much as ours, but it's your responsibility first. And additionally, what if the seller says, I'm not going to use an attorney? So you don't have an attorney to rely on. So it's good to find this information out earlier rather than later. And I know some of those registries are very difficult to navigate. I even sometimes are like, where the heck is this deed? So if you can't find it, reach out to one of the attorneys that you use regularly and ask them to just find the deed for you.
Okay, so the next question is, would all restrictive covenants always be on the deed?
No. So that is, part of the problem. The big ones are usually saying that someone has an easement over the land or something like that, but it's not. It used to be, if it's an older deed, it will list it out there. It'll even say, easement to New England Telegraph and Telephone Company and, those sorts of things. The trend for the last, I'd say 20 years, at least 15, has just been, it'll say something to the effect of all rights, easements, covenants, and restrictions still in full force and effect. So that doesn't tell you anything. You're right. You wouldn't be able to know until a full title search comes back. But again, if your seller is like, yeah, my dad used to talk about someone being able to pull their boat on the side of my house down to the lake, like ding, ding, ding. Okay, let's do some more research now. anything that tips you off. You go and see a weird cart path and it's like, well, who's driving here? It's like, oh, the guy on the back of the property takes his truck back there, or there's a gravel back there that they store. Well, maybe we need to go and find out, is this something that is just we've allowed, or is this something that's actually a written easement?
So, in regard to lead paint in the house, what
Mm-hmm.
about leaded stained glass windows?
It's lead. I mean, it's lead. I mean, are you going to de-lead that? No, and no. So first of all, the lead factor is it's anything that's under 4 feet is really when you're going to de-lead, because they assume that children under the age of 6 are not over 4 feet tall. So it's usually windowsills, baseboards, door jambs, maybe doors, like those sorts of things. So it depends where the lead is, but that's a perfect example of how you could have a new construction home that someone went and got a beautiful, leaded stained glass window, and now you've got lead in the house. But you don't have to know that. It's just a matter of you might have to do a lead paint form on that because you don't know for sure. Or if they do know, then you have to disclose that yes, there's leaded windows in here.
So, this one I think is in regard to tenants not wanting to leave their homes.
Mm-hmm.
If it is a tenant at will, can you get rid of the tenant?
Well, yes, but good luck. So right now, so I have my constable going down today. The tenant needs to be served by the end of this month to be out by May 31st. So we serve the tenant notice, he's a tenant at will, so that they need to be out May 31st. If they are not out May 31st, which we can't physically remove them, then on June 1st, what we do is we go file the eviction notice, and then we go through the eviction process. So you can't, until there's a court order stating that the police is going to be there to remove the person and or change the locks, you can't get them out. You can only go through the court system to get them out, which is why every single time that someone calls me and says and right now you cannot evict people for non-payment of rent. That's one of the reasons that you can't get them out. But uh, usually there's the 14-day notice to quit, there's the 30-day notice to quit, depending on the reasons and everything else like that. But a lot of time, every single time, not a lot of times, every single time when someone calls me up and goes, I want my tenant out, I go, great, give him cash for keys. Because even if you are in the right, which you tenants usually or landlords usually are, and even if they're behind 2 months rent, and you're like, well, why would I pay them money? It's the quickest and cheapest way to get them out. Because guess what? If they're already not paying rent, they're not going to pay rent for a bunch more months. And when you go to court and then you go, oh, okay, well, now you owe me $10,000 for rent. And they're like, well, I don't have $10,000. So your quickest way to, what I say, stop the bleeding, to triage real fast, is to try to just get them out with money.
So, for a waterfront property, if there is no order of condition on record and the conservation committee does not return your calls, what is the buyer's agent responsibility to make sure there are not issues with conservation?
I would say on that, we would probably have to draft something into the purchase and sale agreement that states, that they're usually it says buyer has done all inspections, inquiries, blah, 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 and is now accepting the property as is. That's where that as is clause comes in. I think we end up putting something specifically into the purchase and sale agreement that states, buyer has been unable to verify, determine anything else like that by the conservation committee, and we write something in giving them a certain amount of time, another 10 days or something like that. And then if 10 days we still haven't been able to get a hold of them, we go ahead and extend, almost like a mortgage commitment date. We haven't met that criteria, so we continue to extend. I would need to know a little bit more information about what we're looking for. Is there someplace else that we can find it? But probably not. That's probably where you need to go. And especially during COVID, it's really hard because there's a lot of places that aren't open. They're not answering phones and stuff like that. But hopefully that's starting to change.
So, what if the field card says one bath and there's actually two? Does the home need to be inspected to update the field card?
Well, That depends if the bathroom was put in legally. So if they pulled the permits and the bathroom was put in legally, then yeah, you call up the building department and say, hey, here are the permits that we did. You guys have never updated the field card. Does it have to be inspected? I don't know that they would never necessarily have to go out to inspect if they had the open and closed permits to prove in their building department. Usually when these sorts of things happen, it means that permits were not pulled, and that's why the field card is incorrect.
Is there a statute of limitations that a buyer can sue a seller after the sale?
My answer is yes on most things. I cannot remember because I don't litigate. In Massachusetts, most things are either 3 or 6 years, but sometimes what it is that it's 3 or 6 years from the time that the party bringing the suit knew or should have known. So I don't have a clear answer on that. The answer is yes, there is, but what that date is and when does that time start ticking becomes the question.
Okay, this is a two-part question. What if what if a permit is not pulled to renovate? And do you need lead paint for homes over 1978?
Do you need a lead paint form for houses after? I
Yeah.
always say use a lead paint form. I just think it's just good practice. I know a lot of brokerages require them. Even if you say you write across it house built in 2020 and then you have them sign it or something like that, or you have them fill it out, the sellers fill it out stating like, no, I don't know of anything, and then in the on the side you say house was built in. Because the thing is that again, if the house was built after 1978, first of all, we all know we got paint sitting in our garage or in our basement that's maybe 5 years old. So the chances are there could still be lead paint that we don't realize, because it's not like all lead paint miraculously disappeared from the face of the earth in 1978. And then additionally, we don't know from 1978 to 2021 what has potentially been installed that could have had lead paint. Old windows, like you went and sourced old windows, old floors, old doors, old mantles, anything else like that. So I think from just a protection area, don't get yourself sued, you fill one out. And then I don't remember the first part of the question, I'm sorry.
The other question was, what if a permit is not pulled to renovate? What do you do?
That is a conversation with you and your sellers, and it really depends. So usually the burden of this whole permit thing only falls on the current owner. So if your sellers, the people that they bought it from, put on an illegal deck, the town is usually not going to be harsh on them. They might come in and say, okay, well, we need you to support it a little bit more, or anything else like that. You have to remember, a lot of times I hear things saying, well, the home inspector said it's not up to code. Well, if it was done correctly with a permit, it doesn't have to be up to today's code. It has to be up to what the code was at the time that it was installed. Um, Now, if you did it, you put on that illegal deck, you put on that extra bathroom, you did a huge renovation where you took down walls and stuff. It really depends on the town and how harsh they want to be on you. First of all, sometimes they'll say, okay, first of all, you have to pull the permits, and they make you pay 3 times the amount of the face value of the permit. That's penalty number one. Number two, it just happened to friends of mine in Concord. They did this huge basement renovation. Their contractor said, no, I'm not going to pull permits. They put a porta potty outside because it's COVID, and the building inspector drove by and knocked on the door and said, what's this porta potty doing here? He made them remove all of the drywall. He made them rip out all of the electrical and do it all again, because he was like, listen, you guys didn't get a permit and I'm going to penalize you. Sometimes it'll be the building inspector, depending on what it was, may want you to open one wall to make sure that the electrical and plumbing was done correctly, pull the permit, then close it. It really just depends. It could be a huge issue and it could be not that big of an issue. It depends what you did, how the building department feels about it, those sorts of things. So that's why you maybe don't want to know, because you really want to cost your client potentially $10,000. But at the same time, if the buyer brings it up, you might be costing your client $10,000 and 2 or 3 months of not being able to close because they have to get the contractors out and everything else like that. The other problem becomes if you find out permits weren't closed, like it's an electrical or a plumbing permit, it's kind of hard to get them closed if the original contractor won't agree to come back and close it. because no plumber or electrician wants to put their name on someone else's work because they become liable. So if Joe Black did the electrical and then Cindy Smith comes in and says, "Oh, I'll sign off on your permit for you." If the house burns down because of an electrical issue, Cindy Smith's insurance gets invoked, not John Black's. So it becomes an issue if you can't get the original contractor out to actually go and close those permits.
So if there's a home that needs to be demolished, how do you find out what can rebuild on the property? Possible for a 2 or 3 family on the same footprint? Is it up to the buyer or the buyer's agent to find out with the town?
Um, so if the buyer is buying a house that has been told, yeah, this is condemned, it's it's ultimately the buyer's responsibility, but I think that the house is going to sell faster for more money if the sellers have done their due diligence. Is the footprint still big enough? Is it a conforming lot by today's standards? Is it going to be, or can you leave a certain amount of the house and be grandfathered in? Does it have the setbacks that it needs? Does it have, is it going to need a new septic system? And does the new septic system fit on that lot? There's a lot of questions to ask. So I would say for highest and best sale value, it would be the seller's responsibility, not seller's responsibility. It would be in the seller's best interest to have that information and put it in the listing. And any information that you've got and who you've talked to from a listing agent standpoint to be like, Sue at the building department told me this, and then I talked to Clark and he told me this, and here's the guidelines for a conforming lot. We have enough frontage and we have enough square footage and everything else like that. And although we do not have plans and approval at this time, and remember, there can be a board meeting anytime and it changes, but at this time we know that a 2-family house could be built on this property. But I would still tell your buyers, from a buyer's agent standpoint, you better go confirm all of that information.
Can you comment on agency duty issues, new vulnerabilities, particularly in bidding wars?
I don't understand what you mean by duty agency.
Okay.
I think Bill may have asked this question about bidding wars. So Bill, if you can, or was it Will? One of the two. If you can ask that question just a little bit differently, I'm more than happy to answer it because bidding wars is a real thing in you guys' world right now.
He has several questions here, but I'm trying to get like 1 or 2.
Okay.
What would you advise dual or designated agents, particularly those who are advising buyers to remove inspection or mortgage contingencies? I don't think I understand that question either.
I got that one. I know what he's
Mhm.
getting at.
Okay.
So first of all, I think that, listen, guys, I loved the money when I did it. I did a lot of new construction. And so, buyers would just drive in off the streets into my model home and be like, we want to put in an offer. It's great. I can't tell you that I agree with dual agency. I just don't. How do you serve two masters? And not only that, how do you explain to your sellers that you said originally, I'm here to represent and fight and fiduciary and everything at your highest and best, and now I'm just gonna kind of do it for someone else as well. You almost become a fiduciary. I mean, you become a middleman. And I know that a lot of you are not liking that I'm saying that, but I believe because lawsuits are happening. I know of 3 buyers agents that are being sued right now, and one of them was about that appraisal. I believe that in this market, with everything happening so quickly and crazy stuff happening, you almost write it out in an engagement letter. Like, here are the rules of engagement. This is the game that's being played. And you put it in writing that, you are advising them that to have an accepted offer, especially if the listing agents told you, especially if the listing agent came back and said, listen, we've got 3 other offers and everybody waived appraisal. Are you willing to do that? You have that in writing and say, listen, you need to feel what you're comfortable. Everyone's level for risk is different. In today's market, a lot of people to get accepted offers are waiving inspection, appraisal, mortgage, whatever it is. That is your decision. If you'd like to have a bigger conversation about it, I'd be more than happy to guide you on the pro. Also be happy to have a conversation with your loan officer, if they're thinking about waiving appraisal or mortgage contingency. But you really want to make it clear in some sort of documented way that it is their decision. Because honestly, you're right. In most markets, you are waiving one, two, if not three of the home inspection, mortgage contingency, and appraisal if you want to be a contender. It's as simple as that.
Does the standard inspection clause, any inspections not limited to, protect the buyer in case we find open permits or work done without permit during the inspection period?
The inspection, the inspection language itself, if you're using, I'm assuming they're talking about the GFAR form, not the MAR form, but I might be wrong. I don't know if they're talking about the one of if any mechanical, structural, or other inspections find in the amount of X amount, that's the GBAR form. I do not believe that that inspection, and I've actually recently had this out with quite a few people. I do not believe that that includes permits, but I do believe it's part of your due diligence period. So I think that you should, if you're going to have the home inspection and everything else like that, go look for those permits and everything else like that. Because if you've set the expectation that you're moving forward as is, or you've waived your inspection or anything else like that, and then you come back with, well, now I know this, this, and this, and I want you to fix it. I don't know that sellers in this market are going to be willing to. And the problem with this market, as much as I'm loving that everybody's, got business out there, is that everything's moving way too fast. If you're saying, if you're listing something on Thursday and open houses, are for a couple hours on Saturday and Sunday, and the offers are due Sunday night or Monday at noon or something, that doesn't give you much opportunity to do any due diligence. And it's hard to, for every single property that you think your buyer might want to buy, to try to do all this due diligence. And especially when not all building departments have permits online, and not all building departments are open 7 days a week or anything else like that. You're trying to get this information and still be in compliance of when the deadlines are. So if anything else like that, you might just want to write it into the offer that you're going to be reviewing permits, but at the same time that might be the reason that your offer is not accepted.
All right, well, that looks like that's all the questions that we have for today. As a reminder to everyone, this webinar has been recorded and it will be available to view in the next few days on our website at marealtor.com. If you hover over education and you scroll down to webinars, you have all of our future webinars coming up. And then you can also click our archive of our YouTube channel that has all of our previous webinars to view. So thank you so much, Karla, for your wonderful presentation. I think we all learned so much. And thank you to everyone for joining today. We hope to see you next time.
Guys, it was much fun. Thank you so much. If you have any questions, always feel free to reach out. Happy to answer anyone's just general questions to make your lives a little bit easier and to continue to elevate our industry. Have a great day.